Welcome. My name is David Liwerchik, and this is the inaugural episode of the Illinois Appellate Roundup, a weekly look at the appellate and post-conviction cases that matter most to lawyers practicing in this space. I've been doing this work for more than 20 years. After I graduated from Washington University School of Law, I went to the Illinois Appellate Court for the First District, where I served as a judicial staff attorney and then as a judicial clerk. I helped draft more than 80 opinions in that role. Since then, I've been in private practice handling appeals, post-conviction petitions, and federal habeas matters, over 200 of them. This week is a big one. The Illinois Supreme Court issued 4 opinions in a single day, May 21st. 3 of them are going to matter in courtrooms across the state for years, so I'm going to walk you through all 3: the facts, the court's reasoning, the holding, the quotable language, and what each of these cases actually changes for your practice. Let's dig in. The first case is about a man named Terry Collins, and it's a case that should be on the desk of every Illinois criminal defense lawyer this week. Terry Collins was charged with 4 counts related to a single firearm. The state charged him with aggravated unlawful use of a weapon. They charged him with possessing a gun without a FOID card, and they charged him with being a felon in possession of a firearm. Collins's lawyer did something smart. He asked the trial court to sever the felon in possession count from the others, because if you try a felon in possession charge alongside other counts, the jury hears that your client has a prior felony conviction, and that prejudices everything else. The state did not object. The court granted the motion, so Collins went to trial on the felon in possession charge first. The parties stipulated to the prior felony. The only real question for the jury was a simple one: did Collins possess a gun? And the jury came back with a verdict: not guilty. That should have been the end of the matter. Because if a jury has already decided that Collins did not possess a gun, how can the state turn around and prosecute him for aggravated unlawful use of a weapon, a charge that requires proof of the very same thing? The state said it could. The trial court agreed with the state. The appellate court reversed and said the second prosecution was barred, and the Illinois Supreme Court took the case to decide which side was right. Here is how the court reasoned. The state leaned hard on a federal case called Currier versus Virginia. In Currier, the United States Supreme Court held that a defendant who consents to severance waives any double jeopardy protection that would otherwise stop a second prosecution. The state told the Illinois Supreme Court, that's the rule, and that rule applies here. The Illinois Supreme Court said, not in Illinois. Chief Justice Neville, writing for a unanimous court, explained that Currier interpreted federal double jeopardy law. It did not interpret Illinois law, and Illinois has its own statute, Section 3-4 of the Criminal Code, that codifies issue preclusion in criminal cases. That statute has 2 specific exclusions, and neither one says anything about severance. The court also pointed to a long line of Illinois common law cases recognizing issue preclusion. The state could not point to a single Illinois authority that supported its waiver argument. And here is the holding. When a defendant moves to sever, gets a separate trial on one count, and wins an acquittal, the state cannot relitigate the same factual issue in a later trial on the remaining counts. Severance does not waive issue preclusion in Illinois. The court put it this way, quote, Collins is not attempting to use issue preclusion as a sword to prevent the state from having its one full opportunity to prosecute, but as a shield to prevent the state from having 2 opportunities to litigate the issue of gun possession, which was decided in the prior trial. Close quote. This is the takeaway from this case. If you have a client facing multiple charges that share a common factual element, possession, identity, intent, knowledge, and you can sever one of those charges for trial, you should be thinking about issue preclusion from the start. Currier versus Virginia is not the law in Illinois. Collins is. Save the citation, you will use it. The second case is about a man named Roger Carroll, and it's the most important post-conviction procedure case the court has issued this year. Roger Carroll was convicted of murder in connection with the disappearance of a woman named Bonnie Woodward. After his direct appeal, he filed a post-conviction petition raising 7 separate claims of ineffective assistance of counsel against his trial lawyer. 2 of those claims are worth knowing. First, he said his trial lawyer should have filed a motion to suppress his statements to police. Second, he said his trial lawyer should have challenged the state's radiocarbon dating evidence. The other 5 claims raised additional instances of trial counsel ineffectiveness. The state moved to dismiss the petition at the second stage. The state's argument was simple. Carroll knew about all of these issues at the time of his direct appeal. He could have raised them then. He did not. So they are forfeited. The trial court agreed with the state. The appellate court agreed with the trial court. Carroll's petition was dismissed without an evidentiary hearing on any of his claims. And then the Illinois Supreme Court took the case to decide what the correct forfeiture standard actually is in Illinois post-conviction proceedings, because the appellate court had been getting this wrong. Here is how the court reasoned. Justice Cunningham, writing for the court, drew a sharp line. The question is not, and has never been, whether the defendant could theoretically have raised the claim on direct appeal. The question is whether the facts establishing the claim appeared in the appellate record. If the facts were in the record, the claim is forfeited if not raised on direct appeal. If the facts were not in the record, the claim is not forfeited, even if the defendant knew about it. The court walked through each of Carroll's 7 claims. Most of them depended on facts outside the record, conversations with his lawyer that no one transcribed, investigative decisions that no one documented, strategic choices that were never put on the record. None of that material was available to Carroll's direct appeal lawyer, so none of those claims could have been raised on direct appeal, and none of them were forfeited. But, and this is the part that hurt Carroll, surviving forfeiture is not the same as winning. The court applied the Strickland test and found that Carroll could not show prejudice. The state's evidence against him was overwhelming. Even if his trial lawyer had filed the suppression motion, even if his trial lawyer had challenged the radiocarbon dating, the result would have been the same. So Carroll lost on the merits, even though he won on forfeiture. The court put it this way, quote, "The claims of ineffective assistance of counsel raised in Carroll's post-conviction petition relied on facts not found in the original appellate record and therefore were not forfeited." Close quote. What is the takeaway from this case? 2 things. First, if you are filing a post-conviction petition and the state or the trial court tells you a claim is forfeited because it could have been raised on direct appeal, push back. Ask, where are the facts establishing this claim? If those facts are not in the appellate record, there is no forfeiture. Carroll gives you the citation. Second, do not let a forfeiture victory distract you from the prejudice burden. Strickland prejudice is still the hardest part of the case. Build the prejudice record from day one. The third case is Bright versus Yenchko, and even if you never touch a FOID card case in your life, this opinion teaches a lesson that applies to every constitutional challenge you will ever bring in an Illinois courtroom. Malik Bright was charged with a felony. The moment he was charged, the Illinois State Police suspended his FOID card under Section 8 of the FOID Card Act. The provision that lets the state police suspend your card the moment you are indicted for a felony, before any conviction, before any hearing. Then the felony charge against Bright was dismissed. Bright filed an administrative appeal and got his FOID card back. But in the gap between the dismissal of the charge and the restoration of his card, Bright filed a civil complaint against the head of the state police. He asked for 3 things: restoration of his card, his fees and costs, and an injunction barring the state police from suspending FOID cards based on a criminal charge in the future. His complaint framed the challenge as an as-applied challenge. As applied, meaning the statute is unconstitutional as applied to him. He never asked the trial court for leave to amend. He never reframed it as a facial challenge, but the trial court went ahead and held the statute facially unconstitutional anyway, and enjoined the state police from suspending anyone's FOID card while they were under indictment. The state appealed directly to the Supreme Court. Here is how the court reasoned. Justice Cunningham, again writing for the court, said the trial court made two serious errors. The first error was treating an as-applied challenge as a facial challenge. Those are not the same thing. A facial challenge asks whether the statute is unconstitutional in every possible application. An as-applied challenge asks whether the statute is unconstitutional in this defendant's situation on these facts. A facial challenge nullifies the statute entirely. An as-applied challenge only protects the one person bringing it. The burdens are different. The remedies are different. The trial court cannot convert one into the other without giving the parties notice and the chance to brief it. The second error was reaching the constitutional question at all, because the case was moot. Bright's FOID card had already been restored. There was nothing left for the trial court to order, and the court rejected both of the usual mootness exceptions. The public interest exception did not apply because the case was inherently about Bright's individual situation. The capable of repetition, yet avoiding review exception did not apply because the chance that Bright would be charged with another felony in the future was, in the court's words, purely speculative. So the court vacated the trial court's judgment, vacated the injunction, and remanded with directions to dismiss the complaint entirely. The court put it this way, quote, "Facial and as-applied constitutional challenges are not interchangeable," close quote. The takeaway? When you bring a constitutional challenge in Illinois, plead it correctly the first time. If you mean facial, plead facial. If you mean as applied, plead as applied. If you want both, plead both, and brief both. And watch your mootness carefully. The Illinois Supreme Court will not save a sloppy pleading by treating it as something it never was. This is a pleading discipline opinion as much as it is a Second Amendment opinion. Quick recap before we close. Collins gives the defense bar a powerful new tool for multi-count prosecutions with severed trials. Carroll clarifies the post-conviction forfeiture standard in a way that should change how every defense lawyer briefs the second stage. And Bright is a warning shot to anyone who plays loose with the difference between a facial and an as-applied challenge. One more note before we close. The court also decided a fourth case on May 21st, People v. Marshall, which addresses what happens to your pretrial detention appeal under Rule 604 when your client pleads guilty and gets released from custody before the appeal is decided. Short answer, the appeal goes away, and the public interest exception will not save it. It is a significant case for anyone handling pretrial detention work under the SAFE-T Act. I did not have time to give it the full treatment today, but we will cover it in next week's episode. Make a note. That's the roundup for this week. If you or a client of yours is facing an appeal or a post-conviction matter and you'd like to talk it through with someone who has spent 20 years on this work, you can reach me at my firm directly. The number is 312-517-3877. I take calls personally. Thanks for listening. See you next week.